Hello and welcome to Chat DPS, where after 3 years, the AIC have pounced on Optus. We explore what to expect in a widely anticipated civil suit, and we also look at an update from the Productivity Commissioner as they weigh in on the AI and privacy reform debate. Hi, Adam. Hello, Robert. Here we
Hello.
are again. The weeks seem to be passing quickly.
Very fast, yeah.
So first off, then the Australian Information Commissioner takes a civil penalty action against Optus. So this one came out in September 2022, which is 3 years ago, my lord. Now we're in August 25, and they're pouncing. It's all good. So 9.5 million Australians were affected by this case. It's alleged that Optus failed to protect their personal information from misuse, interference and loss, and from unauthorized access. Modification or disclosure in breach of the Privacy Act 1988. Nice bit of legalese there. The AIC alleges that Optus have failed to adequately manage cybersecurity and information security risk in a manner commensurate with the nature and volume of personal information that Optus held, the size of Optus, and the risk profile of the company. In an interesting interpretation, the federal court can impose a civil penalty of up to $2.22 million for each contravention. And the Australian Information Commissioner alleges one contravention for each of the 9.5 million individuals whose privacy it alleges Optus seriously interfered with. Now, then this is an interesting one, right? Because the OAIC encourages organizations to implement procedures that ensure clear ownership and responsibility over internet-facing domains, ensure that requests for customers' personal information are authorized to access that information, layer security controls to avoid a single point of failure, implement robust security monitoring processes and procedures to ensure any vulnerabilities are detected, and various other bits and pieces. But I'm going to throw into Adam in the first instance for comment when it comes to this. Is my maths a little bit? I mean, I never was that good at maths at school, but this looks like about 10. Is it how many times the GDP of Australia is $21 trillion in a lawsuit?
It's huge. It's absolutely huge, and interesting that it's happening now, especially when there was such other big hacks out there as well. Like one that I was involved in, which was Latitude, which actually has a civil action already against it. So it'll be interesting to see what happens as we kind of as we go through this state. The rules, though, the way they're trying to implement things is a bit of a worry as a CISO. It just seems like more and more compliance for less and less outcome.
Right.
There's a bunch of international standards out there that make you get your foundation in place correctly, and why not simply utilize what's already there instead of building something that is that's written in a very open-ended way. So, put in robust monitoring. Cool. What does that mean? You know, it's these type of things where you've got like NIST, for example, which literally has a set of controls. You just have to meet them. Easy peasy. The essential eight, which the government utilizes, exactly the same thing. It's just the basics of managing your technology and being a good custodian of the data that you have.
Yeah, I mean, I guess, Robert, this is kind of like a class action without being a class action. Yeah, they've made it into,
Yeah,
sort of
yeah.
like each individual has a right, and so therefore we're layering everything over the top of it. Is my interpretation there reasonable?
Yeah, I mean that's probably fair enough because I mean yeah there is a contravention for each individual that's been affected by this. I think there's probably a few things I'd want to say. First of all, the $21 trillion is just like a headline number. That's never going to happen. But I think the key thing is this is all about consequences. And I guess what's interesting is, as you mentioned at the top of this, okay, it's 3 years. So now we've got an understanding. It took 3 years for the OAIC to investigate this and bring this civil action in the federal court against Optus. Look, we've been talking about how under-resourced this particular department has been. So it's not a huge surprise that it's taken some time. We know they've had to outsource a lot of this work to other forensic forensic analysts and law firms to help them along. Okay, so 3 years. So what we know is that Medibank was 1 month after Optus. So I'm hoping, we're expecting that in about a month's time, we'll see something similar with Medibank. And then Latitude was about February or so of 2023. And so give it another sort of, 4 or 5 months, and maybe we'll see some repercussions for Latitude as well. So I think, and with Latitude, don't forget that the penalties increased to at least 50 million. Yeah. So that number is going to go off the charts. If you think 21 trillion is high, Latitude will be off the charts. But I think it's going to be more about, there'll be a consequence. Maybe Optus is going to settle for a number which is significantly lower than that. But I think it's about a consequence. The consequence of Optus, hopefully a consequence for Medibank and a consequence for Latitude. And we'll see if it starts to change industry behaviours, because it knows that the government is actually serious and it's going to follow through. It may take some time, but they're actually going to follow through in the end. So I think that's probably something to think about. I think the third thing to mention is just a reminder that this particular action from the OAIC is on top of the ACMA, so the Australian Communications and Media Authority, also brought an action under the Telecommunications Act against Optus about a year ago. So that's going through the court system. And there's a class action that was brought on behalf of individuals by a law firm against Optus. So there's at least 3 major court actions going through against Optus. So it's one of those things where, again, when you think about, you have a data breach, you have an intense kind of response to that. It costs you a huge amount of money to respond. You might lose shareholder value. So you spend like a year trying to go through like a recovery process, and then years down the line, you get all of these class actions and regulator actions as well. So this one breach, goes on for years and years and years and costs millions upon millions upon millions. So we're seeing Optus go through this, and we're going to see Medibank go through this, and we're going to see Latitude go through this. So again, what I'm going to be interested to see is, what does the rest of the industry do looking at this? Is it going to actually, we're actually going to see a change in behavior? Because I think, to Adam's point, there's a lot of frameworks that are talked about and controls that are talked about, but is there any real action that's being taken by boards, by owners, in terms of responding, seeing these sorts of consequences? Is it going to shift behavior?
And to your point, Robert, with that one, I think the biggest thing is everyone's going to wait to find out what the number really is. Like, what is the actual consequence? How much do I have to worry about this? And if it turns out that Optus gets a slap on the wrist, then it won't be taken seriously at all in the court of public opinion.
That's right.
Yeah, that's a really interesting one there, though, Adam, in that, you're highlighting the fact of, it's a wait and see. We've waited 3 years until now. Actually, when will this actually go? When will we actually get an outcome? I mean, that could be another couple of years, right? I mean, or is it going to be that long? I mean, it's one of those things. But you're right. We need to know what the outcome is, so that the rest of industry, actually, the industry captains out there, the CEOs, the boards of directors, they really do need to know what they're trying to manage to, I guess. And if in the meantime, I mean, they do need to be taking some kind of action. I think they're aware of that. But what that action point is anybody's guess. So anyway, look, moving on, the Productivity Commissioner has thrown the cat amongst the proverbial pigeons on Privacy Act reform this week. Danielle Wood, an Australian economist, and as of December 24, became chair of the Productivity Commission, which was one of the really big things for the incoming government, who were claiming to have a mandate to govern. And now, here we are. And we're moving rather slowly. 6 years on from the start of Australia's Privacy Act overhaul, and we appear to be none the wiser, at least no clearer, about what direction we're taking. And the Productivity Commission is the latest to throw a curveball on where things may be heading, proposing a fresh dual-track privacy compliance approach for business in the interim, harnessing data and digital technologies as part of a report. I was struggling with this myself. I mean, it isn't as if we don't have enough confusion in the space already. with state-based and multiple federal laws and standards already in place, depending upon which industry vertical you're looking at. I mean, Robert, do you want to just sort of like, I mean, I don't know, is it, am I complicating it, or is it already
No,
complicated enough?
it's a hot mess. Yeah, it's a hot mess. It's almost like you wait 6 years and suddenly two buses come along, kind of thing. So you've got another federal agency that's come along with some bright ideas, and and look, it's fine to have these kind of discussions, and it's fine to have these debates. And I think the other agencies have kind of welcomed that. And they're going to put submissions in. So submissions are open. This is an interim report. Submissions are open, and people can contribute to those to this report for the next month or so. Um, but it comes at such a late stage, and I think, but I think it goes to the heart of maybe why things have been going slow. So when the government announced the review of the Privacy Act and the reforms they wanted to put forward, they ended up putting through a first tranche, getting on for nearly a year ago. It looked at online safety for children. It introduced a new tort for serious invasions of privacy. It gave some more powers to the Information Commissioner, but it was pretty low level, and everyone was pretty unimpressed by what happened. And everyone was looking forward to tranche two. Tranche two was supposed to be, okay, here we go. We're going to get to some sort of GDPR level of reform. And like you say, we're still waiting. We're still waiting. We've had an election. The new Attorney General's come out and said, yeah, no, we're going to go ahead with tranche two. Still not quite sure if all of the reforms going to come through on tranche two, but here we go. And then we get this from the productivity commissioners. Suddenly you've got something. You've got this two-track system. Best interests, like in isolation, it kind of sounds interesting. So setting up some sort of defense so that an organization can go, yes, we were acting in the best interests of this particular customer. Then you've got to kind of like drill into what a best interests mean, and it's fine to have that discussion and that debate. However, the context should be the Optus breach, the Medibank breach, the Latitude breach. Are organizations on a daily basis purging their data, encrypting their data, actually looking after the interests of their customers, actually investing in cybersecurity? In that context, sure, let's have that debate. But to be honest, we just haven't seen that sort of behavior. And I think, when it comes to this discussion around regulation, you just need to find the right balance. Clearly, there are some areas where you need a light touch in terms of regulation, and we can look at, some examples around generative AI and that sort of thing. Let's look at making sure that the technology and the innovation can flow. But where you've had history, like in privacy, of years upon years of neglect and poor behavior and massive data breaches, you know what? Sometimes you need the big stick.
Adam, you've got to be having an interest in this, right?
Look, from a CISO or even a CIO or CTO position, this is quite worrying. So there's two areas here that are the main worries. So the first one is they keep talking about the Privacy Act reform and having things like state or federal rules and industry specific regulations. So it just means that you'll have compliance on compliance on compliance, and it'll be very confusing. And whatever happened to the KISS methodology? Just keep it simple, stupid. Like you're the custodian of someone else's data. How do you keep that data safe, right? And just remove all of this other noise and just go, all right, what are the basic tenets to be able to do this, and how should we protect data that isn't ours, right? Which we're talking about privacy data, we're talking about medical records, we're talking about financial data, we're talking about the stuff that will get you in trouble. And I think if we went back to basics and had that conversation, it would look very, very different from a government perspective. The second angle that they're trying to do, which Robert touched on, was a bit of deregulation in the AI space, which is also good and concerning at the same time from a CIO or a CISO perspective. Regulation means that you can move faster, but it also means you can cut corners. So do you get a better product at the end? I don't know. So it will be interesting to see how light touch they really want to go. If they want to go the same idea as what the US have done, which is incredibly light touch, then sure.
Light touch.
I
Yeah,
mean,
no,
yeah, look,
it's
yeah.
phenomenal.
So I was just gonna add to that. It kind of gets back to, so we were talking about Scott Farquhar and his presentation last week. It's like Australia needs to pick a lane. We're not going to be the US. I think Scott has some good ideas around let's focus on data centers. Let's focus on other areas, because we're not going to be building these massive LLMs, but maybe we can encourage investment in those LLMs locally. So first of all, you got to pick your lane. But coming up with ideas like, okay, we shouldn't be regulating high risk AI is one of the things they talked about. Again, it's like context. Have we not just gone through robo-debt? Did we learn nothing from robo-debt? The answer is yes, probably not. It's like, again, you've got to get the balance there. You just can't give powerful tools to people who don't know how to use them without proper controls, without proper risk analysis. And I think that's the problem. It's getting that balance between, okay, let's let the innovation flow, but at the same time, there needs to be some controls and needs to be some checks and balances in place, because otherwise, if you look at the robo-debt and what it did to hundreds, if not thousands of people, because of automated decision making, because that they didn't have the right people, the right controls in place, it's devastating. So you've got to get the balance right. At the same time, let's focus on data centers, because you're less likely to harm individuals. You might harm the climate, but you're less likely to harm individuals. So maybe they should be picking that lane.
Yeah, there's a couple of points there that I think is probably worth making, and that is the fact that people don't make or certainly people in power don't seem to be able to draw the distinction between what a data center is and what's inside of it, and being able to actually throw a whole blanket over the top of it all is kind of it's really disingenuous, and it's really sort of like embarrassing, really, to be led by people that just don't understand that certain people do certain things in technology and other people do different things in technology. So there's hardware and then software, and then there's the housing for it all. The one point, I mean, you brought up the point about Scott Farquhar from last week. I mean, the piece that I was really, really interesting for me that he actually said, and I think this is relevant here again now, is the fact that, we need to start moving at the pace of technology and not bureaucracy. Mm-hmm. Bureaucracy is just going to be a real problem for us if we jump on top of it, if we keep on in this vein. And people not wanting to make decisions is it's crippling. It's crippling for the rest of the world, for the rest of the business community here in Australia. It's going to be awful. So please, you're right, Robert, pick a bloody lane. Let's get in one and actually start doing something properly.
Yep.
Yeah.
We're in a really unique situation at the moment where we can pick a path to clarity, or we can end up in endless debate and regulatory paralysis. And the choice is pretty simple in my head. It's very much like Robert said, right? Pick a lane and get to work on it.
Love it. Guys, that was Chat DPS for this week. Thanks very much indeed for everything and your contribution and raising the ideas. Look forward to catching up with you all very soon. Thank you.
Thank you all.